Who are the newcomers, ma? How many newcomers are there? One, raise your hand properly. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay, around 10 members are there. Okay, no problem. So I think you all are very well aware about paper number 13, corporate and economic clause. So this is the first subject in your entire group 3, and with respect to first class, I think you watch the video in YouTube, first class. Okay, nothing, no subject or content matter has been discussed in the first class. We just had a discussion relating to syllabus structure. So how is the syllabus structure? 60% allocated to corporate laws, 40% is allocated to economic laws. And in corporate laws, how many acts are there? 3 acts are there. First one, Companies Act 2013. Second one, IBC 2016, Insolvency Bankruptcy Code. And the third one, CGCSRSD, Corporate Governance, Corporate Social Responsibility, Sustainable Development. So these are the concepts which contain or which comprise of corporate laws, and the weightage of corporate laws is 60%. Weightage of corporate laws is 60%, and remaining 40% allocated to economic laws. Economic laws, various laws are there. SEBI, Competition Act, FEMA, laws relating to banking, insurance, MSME, PMLA, cyber laws. PMLA means Prevention of Money Laundering Act and all. So this is the structure relating to syllabus. 60-40, corporate 60, economic 40, and in 60, I mean corporate laws. First we are going to start with Companies Act, and in Companies Act also 9 submodules are there. Out of that 9 submodules, various acts are there. First of all, we are starting with topic number 5, Board of Directors and KMP, BOD and KMP. So Board of Directors and key managerial persons, BOD and KMP. First of all, we are going to discuss the concepts which related to BOD, after that KMP. After that KMP. So first of all, who are board of directors? What is the role of directors? So I think you might already know directors are the drivers for running the company. So first of all, as per Companies Act, who is a director? Tell me, who is a director? Do you know anything related to director? Who is a director? Director is a person. Director is a person. That means person. Person means director must be an individual person only. Director can't be an artificial person like a sole proprietorship, partnership, firm, LLP, company. One company can't run another company. One company may hold shares in another company, but one company or one body corporate can't place a role of or can't play a role of director in another company. Just like one blind person can't show a way to another blind person. Here body corporate means blind persons only. Why? Because these body corporates are not having any sort of decision making authority. They are just artificial persons. In order to run the company, in order to administer the body corporate, all you need is human beings. So that is why only persons are allowed to act as directors. Only individuals are allowed to act as directors. So director is a person. Director is a person. Director is a person who is appointed to the board. Who is appointed to the board. Board is nothing but an authority which will make the decisions to administer the business activities of the company. Simple. So director is a person. Director is a person who is appointed to the board. They will collectively called as BOD. They will collectively called as BOD. BOD means Board of Directors. BOD means what, ma? Board of Directors. BOD is nothing but Board of Directors. Whenever you are calling Board of Directors, you are indicating group of persons, not a single person. Single person will obviously called as director. Group will be called with the name of BOD, Board of Directors. And this BOD is collectively responsible for the activities done by the company. Why? Because this BOD is entrusted with the decisions to be taken to administer the company. Whatever the activity company done, say for example, company entered into a contract. Company entered into a contract. Company on its own entered into a contract. No. In order to enter into a contract, the respective decision has been taken and implemented and executed by the so-called BOD only. That is why for anything done by the company, whether it is good or bad, for all those activities, which is the body responsible means BOD. These BOD are collectively responsible for the activities done by the company. Sir, okay. Now I understood who is a director. Director is a person who is appointed to the board. Okay, that's okay. And they collectively called as board of directors, individually called as a director. Okay. But what is their role? Why we need directors for a company? What is the role of directors in a company behind the administration of the so-called company? Basically, 5 roles are there. Those 5 roles are here. First one is what, ma? Fiduciary position. Fiduciary position. Fiduciary position means there is a fiduciary relation between company and directors. I think you know what is a fiduciary relation. Do you know what is a fiduciary relation? Fiduciary relation is nothing but a relationship with a trust and confidence. Tell me, what is a fiduciary relation? Fiduciary relation is a relationship with trust and confidence. Those kind of relations will be called as fiduciary relations. So say for example, doctor and patient. I think this fiduciary relationship concept you have studied in Indian Contract Act, CMA Foundation or CMA Inter. If a relation has been formed or established on the ground of trust and confidence, that kind of relation will be called as fiduciary relation. Say for example, doctor and patient. You approach a doctor regarding your ill health. Doctor prescribed some medicines, or doctor directly gave some medicines, and accordingly instructions of usage also prescribed by the same doctor. Daily twice or daily thrice, like that. You have to consume 2 tablets in a given day or 3 tablets in a day. Some tablets you have to consume with empty stomach. Some tablets you have to consume after having meal, like that. Instructions also cleared. Or one prescription has been given by the so-called doctor. Are you going to cross-check the same thing with ChatGPT or Google? Or if any medicine given by the so-called medical shop agent, are you going to cross-check the same with Google or any other source? No, by simply trusting the doctor's decision making or doctor's knowledge regarding the advice, you are going to simply consume those medicines. That means there is a relationship between you and the doctor, and the relationship is completely formed on the ground of trust and confidence. That kind of relations will be called as fiduciary relations. Which relations, ma? Fiduciary relations. So here also there is a relationship between board of directors and the shareholders. Why? Because who are the real owners of the company? Directors are. Shareholders are the real owners of the company, not directors. Okay, but even though shareholders are the real owners of the company, they can't run the company. They need expert advice from so-called experienced people. Those experienced people, they have to appoint that experienced people to the board, and the board will be called as board of directors. They will cumulatively take the decisions to administer the company. So that is why there is a relationship between directors and the owners of the company, and the relationship is completely fiduciary. So directors should act as trustee and agent of the company. Directors are not expected or not allowed to take personal advantage or any kind of personal gain. This is first point, fiduciary relation, fiduciary position. So role of the director, sir, we appointed director, sir. We appointed director to our company. What he is going to do? He is going to act in a fiduciary position. So the relationship between owners and the directors is fiduciary, first of all. So that means director has to take the decision by keeping this point in his mind. He is not allowed or he is not expected to take any kind of personal advantage. Point number one. Point number two, decision maker. This point you already know this. Decision maker. Who are going to take decision? Shareholders, directors. With respect to strategic decisions and any other decision other than the powers of MOA and AOA, shareholders will take. But day-to-day administrative decisions or how to conduct the business affairs of the company and all those decisions will be successfully taken and executed by this body only. What is this body? BOD, Board of Directors. So directors are there in the company to take decisions. So what we are discussing? We are discussing the role of Board of Directors. We are discussing the role of what Board of Directors will do to your company after their appointment. That is what we are discussing currently. First of all, we came to know that yes sir, directors after their appointment, they will come to their position and take decisions in a fiduciary way. They should always think from this fiduciary position only. They can't take or they are not allowed to take any kind of personal advantages or personal gains or undue gains. So what will happen if they take any undue gains? We'll discuss at a later point of time, not now. So the first point is fiduciary position. What is the second point? second point is nothing but BOD is the decision making authority. BOD is what? BOD is the decision making authority. So whatever the decisions needs to be taken with respect to the company in order to conduct the business affairs or in order to take in a daily course of administrative activities, all those activities will be taken care of by Board of Directors only. That is the role of Board of Directors. First 2 points clear? How many points are there? 5 points. What are these 5 points? These 5 points defines the role and importance or significance of directors. So a question may be asked like this: what is the role of directors? What is the significance of directors? Why a company will need directors? Then you have to elaborate these 5 points. Sir, we need directors due to these activities. 5 points. First one, fiduciary position. Second one, decision making. Third one, compliance officer. Why? Because directors are going to have and possess lot of multi-dimensional knowledge with respect to compliance of various laws. According to SEBI law, what needs to be executed? According to Companies Act, what needs to be done? According to Factories Act, how the things needs to be executed and all. So multi-dimensional knowledge with respect to compliance of laws. Do you know what is meant by compliance? Compliance is nothing but following the rule. Following the rule. So how to follow the rules and all? Directors only know. That is why directors should be there to comply the so-called rules and regulations or to comply the required law of the land. In Contract Act, you have studied, right? Ignorance of law is no excuse. If you simply deviated the law, and you are saying an excuse that, oh, sorry sir, I don't know that these rules are there in the act, I don't know. So is there any excuse? No, you will be penalized or you will be punished accordingly. Here also same rule applies. As a company, in the company form, you are operating the business. Throughout this business activity, you have to comply with lot of laws. So directors will take this role and directors will make sure that your company is complying with all the rules and regulations. So director's role is to play the role of compliance officer. That is why in lot of Companies Act provisions, if company deviated with compliance of any rule or regulation or law, directors will be held responsible, not shareholders. Why you are treating directors as responsible persons? Why? Because as per Companies Act, the role of directors is to play compliance officer role. Company is which person, ma? Artificial person. Company don't know anything. If you direct the company to take left, it will take left. If you direct the company to take right, it will take right. If you direct the company to go straight, it will go straight. Company by itself, it is not having any kind of a brain or decision making authority. Directors are the brain and eyes of the company. That is why if any law gets deviated by the activities of the company, directors will be held responsible. This is one of the point. So 3 points completed. First one is what? Director should act in a fiduciary position. Director should act in a fiduciary position. Second one, directors. Directors are held responsible to take the decision relating to the day-to-day activities and administer the business activities of the company. And the third one, directors are held responsible for the compliance activities. Whatever the rules are there, it is the responsibility of the directors to make sure that the company is following all the rules and regulations. Simple example, if number of employees exceeds 10, you will go under the purview of Provident Fund Act. Then you have to get registered with the authorities, and monthly you have to contribute from employee salary. You have to deduct something, and to that something you have to add another something, and this something you have to deposit periodically to PF account. So all these rules will know by directors only. That is why directors has to make sure that the company is getting complied with all the rules and regulations and laws of the land. That is the role of director. 3 points. Fourth point, strategic planner. Yes, strategic planner means director is responsible to take the strategic decisions relating to the growth of the company. Strategic decisions and routine decisions are not one and the same. Strategic decision is something else which will dictate the future of the organization or future of the company. Say for example, whether to take bath today or not. That is not a strategic decision, that is a routine decision. Whether to take brush or not. Not a strategic decision, it is not a routine decision only. After intermediate, I should opt for commerce related courses or science related courses. That is strategic decision. Why? Because it will dictate the future. So routine decisions and strategic decisions. Routine decisions, anyway, directors are responsible, and directors are responsible for this kind of strategic planning also. So role of director is to play strategic planner role also. This is one of the very important point. Strategic planner. You should dictate the future and growth of the company. Simple example, Ratan Tata is there. Under the leadership of Ratan Tata, in a vertical dimension, whatever, multi-dimensionally, group has been expanded. Group's turnover, net worth, value has been multifolded under the few years of leadership of Ratan Tata. That is the meaning of strategic planning. That means I'm not saying that whatever the decisions taken by Tata are correct, or whatever the decisions taken by Ratan Tata went in a successful form only. No, Ratan Tata faced a lot of failures. In fact, decision making accuracy of Ratan Tata is very poor. Whatever the decisions taken by Ratan Tata are actually initially seems to a very big failures. But somehow group managed to overcome all the failures and stand up in this position today. So that is the power of strategic planning. That is what required for any entity to grow multi-dimensionally in vertical different horizons. So for this planning, who are responsible? Watchmen, huh? Directors are responsible for this kind of strategic planning and all. Not operational level staff, not supervisors, not managers, not employees, not shareholders. That is why make sure that you are appointing creamy layer directors. That means directors who possess valid amount of skill and all. If you know one person and that person is your relative, okay, his feelings will get hurt if you don't appoint that person as a director in your company. Are you going to appoint like that? you are going to appoint like that, then sooner or later your company will liquidate it. Simple. So you should give priority to the skill set, not for the relations. That why? Because are you doing charity by incorporating the company? Are you doing business or charity? Business. Everything is fair in business, not love and war. Okay. So next one, last but not least, representative role. Yes, directors are expected to play representative role also. Sir, what is meant by representative role? Representative role is very simple, ma. If company needs to appoint before the authorities on a judicial trial, any kind of trial it may be GST trial, it may be income tax trial, or it may be any labor laws relating trial, any trial. Say for example, if court issued summons to the company, court issued what? Summons or notices to the company. It is inviting directors to for a small meeting, not inviting company. Why? Because company is which person? Then how come company will attend for the summons? Company will not understand the summons also. Why? Because it is an artificial person. So directors should attend. Why? Because these guys are the responsible for the entire management of the company. That is why these guys has to play this representative role. These guys has to play which role? Representative role. So first of all, so these five are the significance or roles or positions or works to be executed by directors after their appointment with the company. So what you are expected to do or what you need to do after appointment to the company? What you need to do? You have to execute these five roles: fiduciary position, decision maker, compliance officer, strategic planner, and representative. So these are the main duties which needs to be executed by the director after appointment with respect to the company, or with respect to which position they will occupy, or basically director. Lot of types of directors will be there. I'm going to tell you with respect to types of directors. Okay, so first of all, tell me who is a director? Director is a person. Director is a person who is appointed to board of the company. So what is the relevant point, or what is the point needs to be highlighted in this point is person. Person means that is the point which needs to be highlighted while studying. Person means only individual persons are allowed to act as director. No body corporates are allowed to act as directors in another body corporates. This is the first point. And sir, okay, appointment of directors is completed. Okay, we came to know the position or who is a director and all. So we came to know the personal capability or whatever they with respect to director. Okay, we identified the director and we appointed the director to our company also. What he is expected to do? What is his role in the company? Why he is so much important? Why he is so much important means he has to execute 5 duties. He has to execute how many duties, ma? 5 duties. What are those 5 duties? First of all, he is expected to act in a fiduciary position. He is expected to act in a fiduciary position. And second one is what? He is expected to take decisions with respect to the administration of the company. And third point is what? Compliance officer. That means whether he has to make sure whether the company is following proper set of rules and regulations and law of the land or not. If not complying, it is the responsibility of the directors to follow these rules and regulations. And fourth one is what, ma? Strategic planner. So directors are responsible to take the strategic decisions relating to the company. Strategic planner. Last but not least, representative. Representative means what? Representative means what? Representative means directors are expected to represent the company in various trials, whatever the trial it may be. It may be a trial relating to civil issue or criminal issue or whatever the issue may be. Company won't face the legal trials and all. Directors has to face the legal consequences, and they has to represent the company in any trial. That is the case. So these are the 5 roles, or this is the significance of director with respect to the company. And now we'll discuss the minimum number and maximum number relating to number of directors in a company. Number of directors in a company. Sir, how many directors are allowed? How many minimum? Lot of companies will be there. No, Section 8 company, private company, public company, government company, unlisted company, listed company. Lot of companies will be there. So for all these kind of companies, what should be the minimum number of directors, and how much should be the maximum number of directors? What will happen if the maximum number is exceeded and all? Let's quickly learn. Very simple, ma. Minimum number of directors. Minimum number of directors for any company. For any company, this minimum rules should be followed. Maximum rules is somewhat different, I'll tell you. But with respect to minimum number of directors, the order is 1, 2, 3. Simple. The simple order is what, ma? 1, 2, 3. 1, 2, 3. 1 for OPC, 2 for private company, 3 for public company. 3 for public company. I'm going to ask a simple question with respect to public and private. Be ready to face the question. After that, this is minimum number of directors, ma. Minimum number of directors for OPC is 1. Minimum number of directors for a private company is 2. Minimum number of directors for a public company is 3. Let's check out the maximum number of directors. I think you knew it very well. So maximum number of directors for any company, there is no classification with respect to OPC, private, public, nothing. For any company, maximum number of directors are 15. How many maximum number of directors a company can hold? 15 number of directors. 15 number of directors. Sir, what will happen if the number exceeds 50? Nothing will happen. For appointment beyond 15, that means for 16th appointment and for 17th appointment and for 18th appointment and all, special resolution is required. That's it. Which is required, ma? Special resolution is required. That is the only requirement for appointment beyond 15. For appointment beyond 15, special resolution is required. That is the only thing. Usually, a director will be appointed by ordinary resolution. But here, after 15, which resolution is required? Special resolution is required. That is the only criteria. Now tell me, what is ordinary resolution? What is special resolution? Okay. Special resolution is there, no? Tell me, what is special resolution? 75%. That is blunder. Okay. That is not correct. What is special resolution? Anybody? 75 is outright wrong. Why 75 is wrong? I'll tell you. Okay. Any other answers? Any other? Don't you know about special resolution? I think you qualified cmainter, right? No discussion with respect to that qualification, right? Everybody qualified cmainter. Then participate. Tell me, what's wrong in participation, ma? One thing. Always in practice or in reality, in for ordinary resolution or for special resolution, they will always check the votes on the basis of how many votes casted in favor of the resolution, how many votes casted in against resolution. How many votes casted in favor of resolution, how many votes casted against the resolution. Say for example, if you need ordinary resolution, If you has to pass, if you are supposed to pass ordinary resolution, then whatever the votes casted against the resolution, whatever the votes casted against the resolution, they should be less than the votes casted favorable for the resolution. Then it is said to be resolution has been passed, ordinary resolution has been passed. Simple. Few students will say that what is ordinary resolution? If you get 50% vote, it is ordinary resolution. How it is ordinary resolution? Say for example, if you get 50% vote, say for example 100 members are there ma, in order to appoint Mr. X as director, 50% said yes, 50% said no. Tell me, is the director appointed? Just now you said no, ordinary resolution means 50% vote. No, more than 50% vote. Now whatever the point you told also, that is correct only, but you have to add something to 75. More than. So if you need special resolution, do calculate how many votes casted in favor and do calculate how many votes casted against the resolution. For whatever the votes casted against the resolution, say for example, if these votes are 10, so calculate how many votes cast in favor of the resolution. They should be 3 times more. 3x. Multiplication is 3x. So say for example 10 votes casted against the resolution. 10 into 30 how much ma? 30. More than 3x. So exactly 30 happened, just as the case of remaining case 50-50. Okay, more than this is required. Then it is said to be you passed special resolution. So my topic is not to discuss what is ordinary resolution, what is special resolution. So back to our original topic. Why we are discussing about resolutions? Why? Because automatic erase. Okay, erase on lo unda. Okay, right. So what you are discussing, minimum number, maximum number. So what is the minimum number ma? 1, 2, 3. 1 for OPC, 2 for private company, 3 for public company. This is the thing we require. And in case of maximum number of directors, 15 for any company. 15 for any company. And there is no hard and fast rule that a company can't appoint more than 15 directors. Company is freely allowed to appoint more than 15 directors also. And no need of any authorities approval like ROC approval, RD approval, central government approval, nothing needed. All you need is your shareholders approval. Sir, anyway we need shareholders approval, that is ordinary resolution. You need special resolution beyond 15. Why? Because maintaining directors is an expensive affair. Not a welfare or charity ma. You have to pay a lot for the expertise provided by the directors. Ultimately who has to bear these expenses and all? Ultimately owners will be affected now. That is why you have to take approval from directors in the form of special resolution to appoint more than 15 directors. Why? Because ultimately the burden will be maintained by shareholders only. You are not the owner, you are just director. You will simply draw your salary and go away. Ultimately who has to suffer? Shareholders. That is why you, after 15, you have to convince the shareholders. You have to give the justification to the shareholders. Why our company need more than 15 directors? Sir, our company need more than 15 directors. Why? Because our company is having that much workload. In order to discharge this pending workload, 15 directors are not enough. We need something more than 15. For that purpose, we need 15 directors. Or current directors are completely occupied. This guy is occupied in operational activity, that guy is occupied in another activity and all. So in order to discharge some other activities, we need some other manpower. That is why we are recruiting more than 15. In that way, you have to convince the shareholders and you have to give the proper justification to the shareholders. Then only they will convince. We need directors. I'm appointing 20 directors. Give approval. No, they don't give approval. Why? Because maintaining directors is not a silly thing. It is a very financially burden thing for shareholders or owners. Why? Because directors will simply draw numerous amount as salary or for sitting fee also. In order to attend the meeting, for just meeting, they have to spend lakhs ma. You have to provide boarding and lodging. You have to provide to and fro traveling. You have to provide sitting fee. That is why SEBI came up with a regulation saying that sitting fee should be maximum 1 lakh only. Why? Because many people are unnecessarily conducting lot of board meetings in order to just draw sitting fee. Why? Because if they has to attend the meetings and all, sitting fee will be given no apart from salary. That is why maximum cap has been given with respect to sitting fee payment. Only 1 lakh is allowed. Maximum that too. For one meeting, more than 1 lakh is not allowed as sitting fee. Okay. So minimum number, maximum number, 15 for any company. Beyond 15 directors, if you wish to appoint, you can appoint, but you have to convince your shareholders by passing special resolution. That is what we require. And remember, this 15 limit, that means after 15 you have to pass special resolution, right? This 15 limit is not applicable for two companies. One is section 8 company, another one is government company. For these two kind of companies, they can appoint more than 15 directors even without special resolution. That is the point. Now my question is, tell me, section 8 company is a private company or a public company? Private company. Some people are saying private company. Okay, any other answers? Tell me. Properly analyze all the Companies Act knowledge and all. Tell me whether section 8 company is a do you know what is section 8 company? At least give some response ma. Do you know what is section 8 company? Section 8 company is a commercial company. Commercial company. What kind of company section 8 is? Company which is exclusively established for some non-profit activity. That means for charitable purpose and all. That kind of companies are called section 8 companies. Tell me, section 8 company is a private company or public company? Either a private or neither private nor public. Why neither private nor public? Why? Because that is not a transgender, no. It has to be in one category, either male or female. Like that. Neither is not correct answer, ma. Think more. Private company. Okay, private company. Okay, so I'm going to give few more minutes time for thinking. Think hard and tell me whether section 8 company is a private company or public company. What are you thinking, ma? It is a private company or public company? Private company. Private company. Private. Public. Why? Charitable aithe? Neither public nor private. Okay. I don't know. Honest answer. Don't know Companies Act or don't know section 8 company? Whether it is a private or public, you don't know. Very good. Then I know. It is non-profit organization only. It is a private company or public company? Do you have coin? Private company. You have already told the answer, no? Okay. Private. 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 Last guy. Private company. Private company. Neither private nor public. So no one is correct actually. The correct answer is section 8 company Maybe a public company, maybe a private company. It all depends on how you will incorporate that Section 8 company. Section 8, listen carefully. Section 8 is an activity, ma. Section 8 is a activity. You may execute that activity by starting a private company or by starting a public company. So whenever I asked a question relating to whether Section 8 company is a private company or a public company, you should counter ask me, why should there is a necessity for Section 8 company to become only private company or only public company? There can be any company, no? Say for example, I'll tell you, one company is doing education business, ma, or one company is doing manufacturing activity. So if I ask the same question relating to manufacturing activity, are you going to fit that company in either category? No. What you will tell, sir, manufacturing company may be a private company or it may be a public company. It all depends on how you will incorporate the company. Say for example, one furniture shop is there, ma. One big furniture shop is there. They are doing business on a partnership basis. Now, one idea, they wish to implement one idea, and the idea is, Ray, partnership is suffering with lot of disadvantages, ra. All these days we don't know about all these disadvantages. Partnership, joint and several liability is there. Sooner or later we may suffer due to other partners. Let's do one thing. Let's start a private company. Everything, business will be same. We are going to do this furniture business only. Let's start a private company and do the business as usually. And we'll carry on this business as usual. This is one thing. Or they may form a public company also. So, are you defining a manufacturing entity or a manufacturing company either in a private sector or a public sector? No. A manufacturing company may be a private company or it may be a public company. Likewise, here also, if you wish to do the charity, you may do the charity by incorporating a private company or you may do the charity by incorporating a public company. So, Section 8 may be a public company, may be a private company. It all depends on how the company is incorporated. That means I can start a Section 8 public company. I can start a Section 8 private company. Clear? So very important. Why? Because many people will know the Section 8 company, ma. Have qualified cmainter. Don't you know Section 8 company? Definitely you will know. Why? Because it is there in your syllabus also. But you don't pay that much attention with respect to the nature of the Section 8 company. How to incorporate Section 8 company, who has to give the license. For everything, ROC will give the permission. For Section 8 company, ROC don't give the license. Central government has to give the license. RD, regional director will be there, no? That RD has to approve your license. All these things you will know. But the basic characteristics you will forget. Don't forget this point. Tell me, Section 8 company is a public or private? నువ్వు కరెక్ట్ చెప్పేసావు అనుకున్నాను నేను ఇందాక నైదర్ నార్ అన్నావు కదా ఎయిదర్ ఆర్ ఏమో సూపర్గా చెప్పావు అనుకున్నా బట్ నైదర్ నార్ అన్నా సో Section 8 may be a private company or it may be a public company. Both way possible. Don't restrict Section 8 company into one category. Next one. So why we are talking about Section 8 company? Why? Because in order to appoint more than 15 directors, Section 8 company requires no special resolution. Likewise, government company also requires no special resolution. Tell me, what is a government company? Tell me what is a government company? Excellent. That is the wording. That is the wording we require. Apart from the percentages, 50 or 50.1 or 51. Okay, that is also correct only. But that is the wording we need to use. Majority. Majority of the shareholding should be owned by central government or state government or the combination of central and state government. That company will be called as government company. That company will be called as government company. So maximum number conditions are not the maximum number of directors conditions. I mean, if you wish to appoint, if you are planning to appoint more than 15 directors, you have to pass special resolution. This condition is not applicable for two companies. One, super ante. Okay. So let's quickly read out the material. First one is what? Minimum and maximum number of directors, section 149(1). Private company, public company, OPC 1. So these are mandatory statutory minimums. A company may appoint more than minimum. Maximum number of directors. The maximum number of directors allowed in any company is 15. However, more than 15 directors can be appointed after passing a special resolution in the general meeting. In order to avoid unnecessary confusion, I have included this point also. No need to take any approval from any authority, neither from ROC nor from central government, nothing. All you need is approval from your so-called shareholders. That's it. Special resolution. So you are saying that you know who is a director, right? You know who is a director. Director is a person who is appointed to the board of the company. That is the definition of the director. And you are saying that you know what director will do in a company. What director will do? Director will mainly engage in execution of 5 duties, sir. First of all, fiduciary duty. Fiduciary position he will act. The relation between company or shareholders or the directors is of fiduciary relation. Relationship with trust and confidence. That is point number 1. Point number 2, decision maker. 3, compliance officer. 4th, strategic planner. 5th, representative. These are the 5 key roles or significant roles played by the director just after the appointment to the company. 5 roles. After that, you came to know minimum number and maximum number. Minimum number and maximum number. Okay. Key points. These key points I'll cover in the types of directors. We can directly jump into types of directors, and for your clarification purposes, I have given the whole concept in a table. OPC minimum 1, maximum 15. Private minimum 2, maximum 15. Public minimum 3, maximum 15. Each and every bracket contain more by SR. SR means resident director. Yes, I'll tell you who is a resident director and who is woman director. I'll tell you. Next one. This is our today's topic. Next topic, types of directors. So let's complete at least 3 to 4 types and we'll end this session. Total 10 or 14 directors are there. Out of that, let's complete 3 to 4. After that, we'll take break. Not break. We'll resume this session. We'll pause this session. We'll resume tomorrow. So tomorrow is Thursday, Friday. Very good. So types of directors under the Companies Act 2013. First one, executive director. First one is what, ma? Executive director. Simple. Executive director is a director who will take care about the company or who will take active participation in the day-to-day affairs of the company. Just like a managing partner in a partnership firm. What managing partner will do in a partnership firm? He used to actively engaged and involved in the day-to-day affairs of the partnership firm. Likewise, here also, executive directors are those directors who will take the regular decisions or day-to-day decisions or who will administer the day-to-day affairs of the company. Their main nature is to involve actively in the day-to-day activities of the company. So, executive director is involved in the day-to-day management of the company. They are full-time employees of the company. Executive directors includes positions such as MD, whole-time director. MD, whole-time director. In entire Companies Act Board of Directors chapter, this guy is having separate fan base. Managing director. Why? Because this person is entrusted with lot of powers with respect to the company. Substantial. He or she is a powerhouse. And law also treating managing director position in the same way only. That is why law puts a restriction. Do you know or not? I don't know. According to Companies Act, no company should have more than one MD. Power should be concentrated with one person only, in one position only. Multiple MDs not allowed. Sir, I wish to have multiple MDs, sir. My nature of business is like that only, sir. My level of activity is so huge, sir. One person can't manage all the activities, sir. I need multiple managing directors, sir. Yes, you may allow to appoint multiple managing directors, but in the name of not like already when dual sims came, lot of contracts will be saved like this. No, mother 1, mother 2, mother 3, husband 1, husband 2, husband 3. That means same husband only or same mother only, but that mother or father or wife or so called husbands are having multiple numbers. So you can't appoint multiple managing directors to the same company. Power should be accumulated in the one position only. That is why MD1, MD2, MD3 not allowed. If you wish to appoint multiple MDs, appoint in the name of joint MD. To the extent possible, avoid having multiple managing directors. If it is inevitable, if it is unavoidable, sir, I have to appoint multiple managing directors for the company, sir. Appoint in the name of joint MD, not by MD1, MD2, MD3. Why? Because having multiple managing directors is not allowed as per Companies Act 2013. Strictly disallowed. Sir, why we are discussing about managing director? Why? Because he is an executive guy. Who are executive guys, sir? Those guys who are actively taking part and parcel in the day-to-day affairs of the company. They are called as executive directors. They are active participants in operations and management. They are taking active part in the operations and management. So everybody following? So do you really understand who is an executive director is? Why? Because it is inversely related to non-executive director. Non-executive director is a person who should not involve in the day-to-day affairs of the company. He should involve only in the policy making decisions or strategic decisions only. He should not involve in the regular decision making scenarios. So, say for example, in our stores, raw material exhausted. In our stores, raw material exhausted, completed. No raw material is there. Whether to purchase raw material or not, how much quantity we have to purchase, from which party, which supplier we have to purchase, at which price we have to purchase. Those kind of decisions will be taken by executive director, not by non-executive director. Non-executive directors are, but these people are, that is a main difference. And even though non-executive directors are not participating in the day-to-day affairs, they will participate in policy making and they do attend board meetings. They do attend board meetings. They do not hold executive or managerial positions. They play a monitoring or advisory role. Simply, they are critics, ma. They are critics. They will simply they has to analyze the performance of the company from a third party perspective. From outsider point of view, they have to criticize the decisions taken by the company. Criticism is not cussing. బూతులు తిట్టడం అని కాదు క్రిటిసైజింగ్ అంటే. క్రిటిసైజింగ్ మీన్స్ ద criticism should be constructive. That means the criticism should be helpful for the upcoming decisions or upcoming growth of the company. Sir, my job is to criticize, sir. For everything I will criticize, sir. No. Don't be like that. Okay. So they play a monitoring role or a advisory role. Okay. They may be independent directors or promoter directors. Okay, so this is all about executive and non-executive. Tell me what we are discussing. Types of directors. What we have discussed so far. Which chapter we are discussing? Which act we are discussing? Which class is this? What is the area? Very good. Okay. So, what we call premises consciousness is there for everyone, right? So, this is paper number 13, law class. First chapter we have started board of directors in IBC Act. So, directors, okay? Companies Act. Some people already convinced with IBC Act. Oh, we started Companies Act. Fifth one is Board of Directors and KMP. The chapter will be divided into two parts with respect to directors and with respect to KMP. Actually, I have written the whole structure of this act. I think auto erasing feature is no. I think just a minute. This is MSME costing labor MSME hard work handwritten notes directors and KMP costing 13 IBC EO. Okay, somewhere I missed that file. Actually, I have written the total structure. Handwritten notes is something different. Actually, I have already written. This is completely not relevant for you. Why? Because I'm going to give you or I'm going to share this file at a later point of time. As of now, handwritten notes is not required. But with respect to structure of the chapter, I have written. But I'm unable to find where it is. Okay, no problem. Okay, no problem. So, back to our discussion. What you are discussing, Board of Directors and KMP. First Board of Directors we are discussing, and the beginning of the session, we came to know about who is a director. Who is a director? The section numbers and all are not that much important. Few section numbers are important, not every section number. I'm not saying that you have to remember each and every section. No. Few sections. Which sections needs to be memorized and recollected or reproduced in the examination paper and all, I'll tell you. Important sections are there. 184, 185, 186, 164, disqualification, disclosure of interest 184, loans to directors 185, compensation for loss of office 191, 202. These kind of sections you have to remember. Don't try to remember each and every section which you saw in the material. Try to remember and recollect only important sections. Director section is 234 actually. 2 subsection 34, but not that much relevant. Sir, I wish to remember. Okay, it's your headache. So, we came to know about the definition of director. Director is a person who is appointed to the board of the company. And after that, we discussed the role or importance or significance or work is to be done by the director after appointment of the company. We have completed. After that, minimum number, maximum number. For minimum number 1, 2, 3, OPC, private, public. Maximum number 15. Beyond 15 also not allowed. So, allowed, sorry. Beyond 15 also allowed, no problem. But special resolution is required. And this kind of special resolution also not required for 2 companies. Section 8 company and a government company. So, director, role, minimum number, maximum number. Now we are discussing currently types of directors. Out of the 2 directors completed. Executive, non-executive. Executive is a person who is not involved in the day-to-day affairs of the company. Involved, Auna. Okay, very good. So, if a director is not involving, then non-executive director. So, non-executive director's role is to play a critic role or an advisory role. So, he won't participate in the day-to-day affairs of the company. He will participate only in the strategic meetings or board meetings or policy decision meetings and all. Only important meetings only he will participate. But when it comes to executive director, he used to visit the office, that means company, on each and every day. On a regular basis, not each and every day, on a regular basis. Why? Because he is responsible to take the administrative decision with respect to the company. Clear. Third one is managing director. Third one is what, managing director. So, first 2 points are executive, non-executive. Third one is, in that executive director, managing director is a category or a person. So, managing director, according to section 254, MD means a director who is entrusted with the substantial powers of management of company affairs. substantial powers, significant powers, not minute powers or insignificant powers or unwanted powers or immaterial powers. Substantial powers this guy is holding. Even though, say for example, if a director is holding substantial powers, but that guy position is not MD, for administrative and for company law purposes, that guy will be treated as managing director. Say for example, one of the executive director is there. His position is ED only, executive director. Or by the name of CEO or by the name of CFO, we are not calling him with the name of managing director, and there is no managing director in your entire company. There is no managing director in your entire company. Even though there is no managing director in your company, even though there is no managing director in your company, this guy is there, no? The person who is holding substantial powers in your entire company, that guy will be treated as MD for the Companies Act purpose. Sir, our company people are not recognizing my powers, sir, but you recognized, sir. Thank you so much, sir. Now what I am supposed to do? Go to jail. Why? Because Companies Act will define you whenever there is contravention or whenever there is deviation from law, then only Companies Act has the necessary to define you. For this contravention, you are responsible. Okay, one positive thing, one negative thing. Okay, so this is the thing. MD is a person who is having substantial powers with respect to the management of company's affairs. The key points are: MD may be appointed by an agreement or by resolution or by MOA, AOA. These three are different cases. These three are different cases, not a equal thing, or not will not happen in a one single scenario or one single circumstance. MD may be appointed by agreement, means shareholders will not appoint managing director. Shareholders will just appoint BOD only. BOD only. So Subbarao, board of director, Apparao, board of director, Ankatrao, board of director, Pullarao, board of director. So likewise, X, Y, Z and all, they will constitute one board. If you require managing director, you may appoint one person as managing director from among yourself, or you may recruit another managing director from outside also. So we are not going to appoint MD in our meeting. Our meeting means AGM or EGM. We are not going to appoint MD in this general meeting. If you require, you may appoint. That means shareholders are delegating their power to directors. Actually, who is responsible for the appointment? Shareholders are only responsible. Why? Because they are the owners, no? Tell me, who are the owners? Who are directors? Agents of the shareholders only. Directors are nothing but agents of the shareholders only. They are interested to act in the best interest of the company. They are interested to take the decisions relating to company for the well-being of the company. So listen carefully. Directors are there, no? These directors, shareholders are there, no? These shareholders are the owners. They should not involve in the day-to-day affairs of the company. Sir, who restricted them from involving in the day-to-day affairs? Companies Act only. That is why there should be a formal body. There should be a formal arrangement to run the company. In simple words, we can simply identify that owner is different from director. So the drivers who are running the company, they will be collectively called as board of directors, individually called as director. So these directors are there, no? Appointment of these directors' job is the responsibility of shareholders. Why? Because they are the owners. They are the owners. And the job of the shareholders is to appoint MD also, managing director also. Job of the shareholders is to appoint managing director also. But sometimes, if shareholders got no time to appoint MD, or shareholders are in a confusion whether to appoint MD or not, or whom to appoint MD, by whatsoever reason, if shareholders didn't appoint MD, they may delegate the same power to remaining board of directors that in your regular execution of jobs, if you require MD, you may appoint one MD. That is your decision. Actually, we are supposed to appoint, but we are simply delegating our power to you. Delegation of powers. Then board of directors may recruit an MD from outside after formally convening interviews, after verifying so many profiles and all. So they may appoint an MD, and that MD is just an employee of the company. Even though he is an MD, okay, he is going to have substantial powers of the company, but he came into the company by agreement. He came into the company by agreement. That is the thing. Second one, resolution. Resolution means not board of directors, in general meeting, it may be AGM or it may be EGM, members appointed this person as MD by passing their resolution. Don't think that for appointment of MD special resolution, why? Because he's a powerful person. No, by normal resolution, that is by passing ordinary resolution only, MD will be appointed. So when agreement will be there? If the MD's appointment is done by BOD. When resolution will be there? When MD appointment is done by board of directors or shareholders are? Shareholders. And the third point is also there. MOA, AOA. At the incorporation stage itself, you may include appointment of MD also. But listen carefully. According to Companies Act, this is a advanced point. You will learn this point at a later point of time, but on a brief note, I am saying this point. MD's appointment should be done to the maximum of 5 years only. After 5 years, if you wish to really continue with the same person as MD, you may reappoint again for 5 years. Sir, 10 years passed, sir. This guy is working very hard, sir. Our company is in a growth manner only. Our company is continuous profits. We are experiencing continuous profits. We wish to continue with the same person only. Okay, no problem. Carry on. Sir, 15 years completed, sir. We wish to continue with same person only. It is your headache, man. Go ahead. Sir, till that, how many times we can appoint, sir? What judge nee istam. You can appoint MD n number of times. There is no concept of cooling period to this MD. There is no concept of cooling period. But the only restriction is one term appointment should not exceed 5 years. And another point is also there. Reappointment should not be done within reappointment should be done only within last year only. Say for example, we appointed X as MD for 5 years. 2 years completed. How much remaining term is there? 3 years. Sir, this MD is working very hard, sir. We will reappoint again him only, sir. Let's pass resolution. No. No, you will take the continuation or discontinuation decision only in the last year. That means 4 years should pass. After that, you will take the decision with respect to whether to continue with the same guy or appoint another person as MD. Appointment or reappointment should be done only in the last year. And at a time, you can appoint MD to the maximum term of 5 years. Sir, why these points are not there in material, sir? They will be in your material only. But at a later point of time, you will experience these points. In remuneration and KMP topic is there, no? What is our chapter name? Directors and KMP. Directors we are discussing. That is why on a simple note, I have included few points related to MD. That's it. So MD is a person who is having substantial powers of the management with respect to the company. Key points are, first one, MD may be appointed by an agreement, resolution, MOA, AOA. Second point, MD involved in the, it's obvious why, because MD has to involve in the day-to-day affairs of the management. Okay, very good. With respect to CMA, Curriculum only. Nice. So, what we are discussing, ma? MD is involved in the day-to-day management, and only one MD can be appointed in a company unless it is a joint MD. I think you know this point. 2 minutes back, I have explained this point, ma. Having multiple husbands is a crime, or multiple wives is a crime. Polynomy is not allowed in India. Like that, here also, having multiple MDs for a same company is a crime. You are not allowed to have multiple MDs for one company. Sir, I wish to have multiple MDs, sir. Okay, you can have them by joint MD concept. That means you are distributing the powers. Power will be concentrated in one position only. Okay, so MD1, MD2, MD3 not possible, not allowed, not possible and not allowed as per Companies Act. So first 3 points clear. Which chapter we are discussing? Directors and KMP. First one, who is a director? Role of director, minimum number, maximum number. Types of director, executive. Fourth one is whole-time director. I have already told you, 3 to 4 terms we'll discuss, and let's end up the session. So whole-time director. So simple, ma. Whole-time director is a full-time employee of the company. Whole-time director is a full-time employee of the company. He should 100% involved in the day-to-day affairs of the management. This whole-time director has to be with our company on a 100% basis. Why? Because listen, whole-time director, what is the basic difference between any other director and whole-time director is whole-time director will invest his blood and sweat for the growth of the company. 100% he is going to invest his efforts in the growth of the company. Whole-time director, there is no option. So just like an employee, we will treat this WTD not as a director. We will treat WTD as a employee of our company. So whole-time director is a full-time employee of the company as entrusted with regular duties, like whatever the duties that are having by executive directors, and this whole-time director is a subordinate person to the board and MD. Sir, what is meant by subordinate? Subordinate means one rank below. Subordinate means what? One rank below. He is not at par with MD, or he is not at par with board. That's why I have specifically highlighted this word in your material. What is a highlighted box? Full-time employee. Amma, our employees and directors are equal. Somewhat differentiation should be there between employee and director. No, that is the differentiation. That is why WTD, even though we are pronouncing him with a position called director, he is not at par with the director. He is employee. He is required to devote. Devote means invest or allocate whole working time to the company. You may act as director with 10 companies. Yes, possible. 15 companies, possible. 18 companies, possible. 20 companies, possible. 21 companies, not possible. I'll tell you how many companies allowed and all. I'll tell you at a later point of time. In this chapter only, you will get to know for how many companies a person is allowed to act as directors and all. I'll tell you. So, but whole-time director, you are allowed to act as a whole-time director in one company only. Why? Because you are a full-time employee. Say for example, after your qualification, are you allowed to work on a full-time basis with 2 or 3 companies? No. If you are a consultant, or if you are into practice, or if you are into teaching or something else, then you may engage with a lot of institutions and lot of employments. Why? Because everywhere you are working on a part-time basis only, not full-time. But this guy is working. This guy is working on a like a full-time employee. This guy is working like a full-time employee. That is why the significant point in this scenario is this guy is the subordinate. This guy is a subordinate to the board or MD. Subordinate means not equal, not at par, not equal, just one rank below. or maybe 2 rank below, whatever it may be, just not at all equal. That is the point. So 4 points completed. Executive director, non-executive director, managing director, whole-time director. There are a lot of points which needs to be covered. Ma. So MD completed means, sir, MD only 3 points. This is basic introduction only. In Schedule 5 Part 2, you are going to learn about Part 1 about appointment of persons and talks about managerial remuneration Part 2. That point or in that scenario, you are going to learn some more points about these guys, MD and all other directors. This is basic introduction only. Clear? So we are discussing currently the types of directors, and in the types of directors we completed 4 points. How many points we have completed? 4 points. First one, executive director. Second one, non-executive director. Third one, managing director. Fourth one, full-time director. So we started with chapter 5 of Companies Act, which is directors and KMP, and we started directors zone, and we came to know about who is a director, what is the role and significance of director, minimum number, maximum number of directors, and types of directors. Currently we are discussing. There is a lot to discuss about types of directors. Tomorrow we'll continue this same discussion. Tomorrow we are going to start with this guy, very important guy, very important. So he is going to have so much priority according to Companies Act 2013. Who is that hero? Independent director. Sir, can we also be eligible to act as independent directors? Yes. If you wish to act as independent director of some companies, you please go and register in the portal. 20,000 or something else you have to pay. If you have that much money, go and register yourself. Who knows? Any company may appoint you as independent director. Why? Because all they require is an unrelated person. They has to appoint one unrelated person as independent director. So who knows? If you spend 20,000, you may be appointed as an independent director with any other company, and at sitting fee only you may get up to 1 lakh. Okay, one of my friend did the same, and currently he is acting as director with a Rajasthan company. That is a suitcase company actually. After knowing that this is a fraudulent company, immediately he withdrawn from that company. So that's not a big deal now. So you might be wondering, sir, why that company specifically appointed your friend as independent director? All they need is only one unrelated person. They don't require your beautiful knowledge and enormous amounts of knowledge. They don't even know you. That is what they need, no? Independent director means the person should be unrelated with the company. The person should not belong with the promoter or promoter group. He should not hold any shares in the company. Any person who satisfies this criteria, they has to check. In the independent directors portal, they checked. His name is Abhilash actually. I think they didn't even search it more. In A category, alphabetical A category, Abhilash, A, B. Let's appoint this fellow as a independent director. Who knows? But he attended for one meeting, and sitting fee also he received. After attending for that board meeting only, he came to know that this is a shell company, non-operating company. So that's why he immediately withdrawn. That is a different case. So topics related to independent company and all we'll discuss in tomorrow's session. Okay. So are you able to follow the classes? So are you getting the clarity? What kind of concepts you are discussing? Right. Very good. Let's continue this discussion tomorrow. Thank you.